Good evening. Welcome to Lawyers on the Line. I'm Jim Peterson, a partner at the Falsani Balmer, Peterson, Quinn Beyer law firm, and this evening's moderator. Tonight we're talking about workers' compensation. When an employee gets injured on the job, that employee has the right to a number of benefits under the law. Handling medical bills and wage loss, changing doctors, getting back to work, and just navigating the system can all be very complicated. Here to talk about these challenges and answer your questions are tonight's panelists. Kathy Bray, in-house counsel for SFM Mutual Insurance Company here in Duluth. Bob Falsani of the Falsani Balmer firm. Sean Quinn of the Falsani Balmer firm. Call us with your questions about workers' compensation. The local number is 218-788-2844, or if that's long distance for you, you can call our toll-free line at 1-877-307-8762. Let's get to some questions. We've had some questions come in the office this week about doctor exams. Somebody's got a work injury and they're dealing with the system. Sean, tell us about a medical exam that the insurance company schedules.
When somebody gets hurt at work, one of the obligations under the law is if the insurance company says, we'd like you to be examined by a doctor of our choosing, the employee has to attend that and go to it. Typically, it's an orthopedic doctor if it's an orthopedic injury, things like that. Whatever the injury is, the type of doctor you're going to see. And for people injured up here in northern Minnesota, there aren't a whole lot of doctors that do that kind of work for insurance companies. So oftentimes the insurance company will send doctors up here from the cities or ask the employee if the employee would be willing to go down to the cities for the exam. They'll pay the mileage. So it's an obligation of the employee to do that.
Okay, but here's the follow-up, Bob. We get the call in the office, and here it is. I've already got doctors. They already told me what I can do at work and what my treatment should be. Why do I have to listen to this doctor who saw me for a quick exam at the request of non-SFM insurance company?
Well, when you're going to see the doctor for the insurance company, it's time to walk the plank, okay? Because
do I get to answer this question?
The ones, when we cross-examine them, and a few of them are honest enough to tell us really what's going on, they tell us that they deny 95% of the cases. And of course, that's what we see from the usual suspects that do these examinations. I mean, they never help the employee. I mean, it just never happens. So every once in a while, they'll grudgingly go along that if somebody got a spear in the chest, that it hurts.
Okay, Kathy, you're representing the insurance company, and you're getting these weekly workability forms, regarding why would you want to get an outside opinion?
Well, it's more complicated than Bob and Sean may make it sound. And frankly, the doctors I have seen, some of them will find in, quote, favor of the employee, some will find in favor of the employer and insurer. Typically, a complicated medical situation has arisen. There is a dispute perhaps between what objectively is being presented and what subjectively is being complained of. There might even be just a very complicated surgery question or treatment question that you need a second opinion on. There's a variety of reasons that you would need an independent medical examination to help clarify or potentially move the claim forward.
Okay,
here's one other thing about this. If you're going to have this exam, you can always call our office or another office that does this kind of work, and they'll send you for free without any questions asked some instructions for when you go, so that at least you have a fighting chance later.
Kathy, we have a question about a bad knee. The caller had a bad knee since a football injury, it sounds like many years ago, gets twisted at work and now it's worse. Is that a workers' comp situation?
Maybe. The situation presents with a pre-existing condition, so there's always a question of what is new and what is old. It might be a question of the scope and extent of the injury, but if they injured something at work, that aggravation may be compensable. It depends on how it happened and whether it actually arose out of the work activities.
Here's a call, just came in. Bob, you get to take this one. Post office worker, hurt on the job. Why won't any local lawyers take the case?
Federal workers' comp. It's not made in heaven. When I've I used to handle a few of those cases, and sometimes you can write a letter and get an answer to it within a year. And then the client is making an ethics complaint because it's your fault. It's the most ridiculously run system. They did a study of federal agencies some years back, and they said that was the worst federal agency of all of them, worst run. So
The work comp agency.
yeah.
Yeah.
And I had another case where they were paying my client for a very minor injury, and they kind of lost the file. They paid her like 8 years of benefits, and she had about a 6-month injury. It was great. Too bad,
And there's one other reason why local lawyers, a lot of lawyers, won't do federal workers' comp, and it's an honest answer. It's somewhat selfish, but it's honest. The only way a lawyer can get paid by representing an injured worker in the federal system is they have to succeed, and then they have to ask the government to say, please approve of a fee, and then the government drags their feet and delays, and then ultimately approves a very cut rate fee. So when a lawyer knows that they're very unlikely to get paid a fair fee, they're just not going to take the case.
Sean, here's a question for you. It's a little bit topical, although you wouldn't expect a slip and fall in April in Duluth. But let's say you're in your employer's parking lot, you get to work, you get out of the car, take 3 steps and you slip and fall, boom, and you got a tailbone injury, let's say. Yeah. Is that covered, or is that
What
not?
time of day?
You're just getting to work. You have not clocked in yet, let's say.
Yeah, when you're at the employer's parking lot, you are covered. The employer, your job as far as workers' comp is concerned includes what's called safe ingress and egress. So you're driving to work, you're not covered. You park your car, you open the door, now you're covered. So as long as and it doesn't even necessarily have to be the employer's parking lot per se, but the usual parking lot where you park.
Okay, similar situation, Bob. You go outside to smoke. You want to smoke a cigarette, you slip and fall in the same spot that somebody else fell earlier that day.
It's usually covered by the personal comfort doctrine, which basically is, you can do certain things at work to relax and whatever from time to time on your break, and so usually covered. Now, if you decide you want to get in your Jaguar and drive 100 miles an hour down the road, you're probably not going to get personal comfort coverage. So.
Kathy, I know you're a runner, a jogger. This is a situation I was wondering about. The boss says, you know what, we're going to do a walk run for charity on Saturday, and everybody's welcome, and I'll even pay you for your time. But if you don't want to help out our charity, you don't have to come, but you're not getting paid.
So you're getting paid if you go.
Yes.
You don't get paid if you don't go. And is this your normally scheduled day?
Either way.
Well, to me, that makes a difference. I mean, are you being punished for not participating, or is it sort of a bonus if you do participate? Because typically, if it's a voluntary recreational activity, you are not going to be within the scope of the work comp act if you're injured. However, if it's something where really there's more of an implied pressure, you have to participate, it's not so voluntary, they'll look at the facts of were you paid, were you punished, if you didn't go, things of that nature. So some of the facts may vary, but if it's a purely voluntary recreational event, company barbecue on a Saturday, there happens to be a fun run with it, that's not going to be a work comp injury.
Anybody know of a recent Supreme Court case that?
Actually, that's true. The Supreme Court just decided a case, and Kathy kind of hit the nail on the head. In that particular case, it was voluntary, but it was during the workday hours, and if you didn't want to volunteer, you had to take your sick leave, or you could take paid time off.
Correct.
Or unpaid time off. And the court said, well, that really punishes, to use Kathy's word, that really punishes someone for not volunteering, so that's going to be covered.
Let's do a lightning round. We do this workers' comp show every year. Sometimes the questions get a little repetitive. The last couple of years, what's the most important development in Minnesota workers' compensation law?
Well, the Dykoff case is interesting, but I don't consider it a new development. It was a Supreme Court case as well that talked about whether A work injury arises out of an increased risk of employment. It was a walking across a flat surface, trip and fall, pretty severe injury, and ultimately was not found compensable. It created a lot of activity and a lot of interest over what is and is not an increased risk of employment.
Bob, most important development last few years.
The adoption that Dr. Freud had something that he knew about in terms of psychiatry, and allowing a grudging amount of work stress, allowing PTSD claims. So we finally have opened the door to psychiatry in 2013. And so they finally passed a statute, and they said only PTSD would be compensable if it was caused by emotional stress at work. Like you're a teacher and the gunman comes in and slaughters 11 kids in front of you, you'd have a compensable claim then. Up until October 1, 2013, that was not compensable.
In Minnesota.
In Minnesota. It is in Wisconsin and has been.
Sean, important development the last few years.
Just earlier this year, the Supreme Court issued a decision that changed the general understanding of all work comp practitioners as to what is required in order for somebody to obtain permanent total disability benefits. We had a law changed in 1995 requiring a certain threshold of a different benefit, and there was a lot of playing around with it, the permanent partial disability. The Supreme Court said only real permanent partial disability counts, and they didn't define that, so there's going to be even more litigation thanks to the Supreme Court's interpretation of the law.
It has to impact your ability to work.
Right, but they didn't decide what that meant. So.
Right. I mean, do you know in that particular case what the claimed disability was?
In that particular case, whatever the guy's work injury was, I don't remember. But the extra thing that he had wrong with him that allowed him to at least make a claim for permanent disability was that he had no teeth, but he had full dentures. And having no teeth allowed him what's called an additional 10% of disability. And the courts all said, yeah, well, that gets him over the threshold, and now we can address the facts of whether he can or can't work. And the Supreme Court said, nah, that doesn't count, because that's not real. So he can't even have the opportunity to prove up his claim now.
Kathy, here's a question. My doctor prescribed antidepressants because of my work injury, because of the pain and disability, I imagine. And I haven't been able to work. Can I get that covered?
That's another, not to have a lawyer answer, it depends. Under the Work Comp Act, if there's a consequential injury stemming from the original injury, you can have it covered by workers' compensation. When it comes to consequential psychiatric or depression questions, there's sometimes the question of whether that's stemming from the injury itself versus feeling depressed because you can't get to work, you're not socializing as much, things that are not related to the injury itself, and those would typically be denied.
All right, but if the doctor says it's because of your back and you didn't have it before, is that more likely, or is this a case where you might send out for a different opinion on that?
If there is a dispute that arises over it, the insurance company denies, and then they perhaps obtain an attorney. You file a medical request to get that medication covered. The insurance company would likely have a second opinion from a doctor of their own choosing to address the question, and whether it's consequentially related or something that may be a separate, more economic, social issue.
It's just so common because of the cluster of disaster from a serious injury that displaces a worker. You know, the person doesn't have his socializing at work, the money's not coming in, they don't feel great about themselves, they're in chronic, horrible pain, their marriage is falling apart, the kids hate them. I mean, you know, it can be really a tough thing to go through, and so anxiety and depression really go with the territory for a serious injury. So common.
Bob, I'll stick with you on this one. A call just came in. Sounds like it's from a lawyer. It says, how does Dykoff impact a slip and fall injury at work?
Oh boy, just opened Pandora's box.
We don't have this much time.
Yeah. What happened in Minnesota is that there's a body of case law that's been around for years, and it basically said, look, If you're walking on a nice flat floor and there's no problem with it whatsoever, and it's not slippery and so forth and so on, and somehow you manage to fall down and break your kneecap, it's not going to be compensable. And the Dykoff case was similar facts like that, except for the woman had high heels on that she had to wear and she usually didn't wear and going to some meeting. And so there was that little aspect of the case, and there might have been a little bit of rushing, but they didn't really develop that. And the Supreme Court said, nah, that's not compensable. And it wasn't really a landmark that way. The problem was that in the Supreme Court's decision, there was a lot of blah, 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 blah that opened up all kinds of Pandora's box kind of things that's scary, 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 and it's resulted in all kinds of claims being denied, even by SFM.
Yeah. Well, the real significant consequence of what happened was that a lot of insurance companies took some of the language from the Supreme Court's decision and they've interpreted it to mean if you get hurt on the job, but you get hurt in a fashion that could have happened anywhere else, so forgetting about the smooth, flat surface, you slipped on the ice. But you could slip on the ice not at work too. Well, it's not covered. Now, that's not what the Dykoff decision said, but that's how it's been interpreted by a number of insurance companies. And now there's a whole bunch of more cases that have come from that are now heading to the Supreme Court, where lawyers and their clients are asking the Supreme Court, is that what you meant, or did you mean something else? And so we'll get a decision maybe later this year, if not next year, on that.
And it really was a drafting problem, that there was a sloppy decision issued by the Supreme Court. It was so overly broad with all kinds of silliness in it, and it was just poorly done. Well, and we all knew it was going to be a gigantic horror show.
It comes, though, down to the question of whether there was an increased risk related to the work activities or the work environment. Right. And that was pretty clear, and it wasn't a bunch of mumbo-jumbo. And so what it caused, I think, is employers and insurers to look more carefully and critically in those more commonplace decisions, like going up and down stairs when there's no hazard, going across a flat floor where there's no hazard and someone trips and falls and they can't explain why they tripped and fell. So I think it isn't necessarily a poorly crafted decision or something where people are creating something that's not there. It's a matter of re-examining what is the increased risk related to a work environment.
Stairs are not floor, okay? It's a change in elevation. I've got a bad knee from football, and I got to tell you, I hate stairs.
Did you call in earlier?
Yeah.
Was that your call earlier?
No, it wasn't. No. Yeah.
Sean, here's a question. If I hire someone, I assume this is like a homeowner, okay? Hire someone to do a job, some yard work, and this person gets hurt because they fall off a ladder or something. It's not specific what exactly happened here. As a homeowner, do you have to buy workers' comp insurance and cover yourself for that?
You do not. You're not an employer. That person is not an employee. That person would be considered an independent contractor or something like that. We run into that situation everywhere. All kinds of people hire individuals to do a simple job, things like that. So that's not required. If you hire a company to do something, you make an agreement with ABC Contractor, and they bring employees on the job. Of course, that company presumably has work comp insurance for their employees, but the homeowner is not required to buy homeowner's insurance for hiring somebody to rake their leaves or get the snow off the roof or anything like that.
But if it was really common and it was done over a long period of time and a lot of money changing hands.
If it was the same person you were hiring over and over, yeah.
It gets beyond casual employment.
Yeah.
That's more of a caretaker situation where you have an ongoing relationship then.
Right.
Well, and of course, it could easily be a situation where it's not workers' comp, it's a liability case, right? I mean,
oh, sure.
If you say, come clean my gutters out, and you give them a lousy ladder, then that may not be a workers' comp. You may have a different issue on your hands.
And then hopefully your homeowner's insurance will cover you for that.
Mm-hmm. Or the dog bites him when he's on the ladder.
Oh, I don't think we have to bring dogs into it.
Labs. We have labs. They wouldn't bite anybody, right? Yeah.
Am I covered under workers' compensation if I'm making a delivery or traveling to a meeting during work hours and get into a car accident, Kathy?
when you say I'm going to a meeting or doing a delivery, is the delivery related to your work activities, or are you delivering a present to your son's classroom?
Well, I assume this is a work situation.
Okay, because I mean that's the question: is this errand you're doing during your work hours work related? Is it furthering the employer's interests, or is it something that's more of a personal benefit to you? If it's more work related, chances are that would be covered as part of a work comp question. But if you had, as I think Bob mentioned earlier, a personal errand, you deviated from your work path, then that's going to take you out of the work comp system.
So the kind of thing is very fact specific.
Correct.
I think is what, yeah. We already asked that one. I got hurt this week at work. I reported the injury. The claims adjuster is calling me on Monday. Do I have to call a lawyer, Bob?
Well, you usually don't have to call a lawyer, and most of the time people just give these statements and so forth and so on. The trouble is, every once in a while, people do something so dumb in that statement that it haunts them throughout the case. They lie about something. They don't tell about some pre-existing treatment that's asked about. They're asked about the essence of the case, something important like why they tripped or why they fell. They run into a Dykoff defense because they say, well, I don't know why I fell. Okay, fine, see you later. You're not getting any money. So it can be really important when you give that statement. The trouble is, in workers' comp, a lawyer's not paid to give advice or anything like that. There has to be a contested case before they can get compensated. You probably can call a lawyer and get 5 minutes of free advice on giving the statement. You know, if somebody called our office about that, we'd tell them what to look for. But most of the people are on their own for that statement. It's different in personal injury, but not in workers' comp.
Sean, do all employers, it gets back to the casual employment situation, but let's say you have a small business, do you have to have workers' comp insurance, and what happens if you don't?
Well, you have to have workers' comp insurance if you have employees. You know, at our office, you know, there's 5 partners, but we have, 20 total staff or something like that. We have to have work comp insurance for ourselves, or for our employees. You do not have to buy work comp insurance for yourself if you're a business owner. You have to elect it or elect against it. So the business owner, himself, herself, you don't have to buy it for yourself, but you have to buy it if you have employees. Simple as that. And if you don't, then one of your employees gets hurt, then they can make a claim against you. You have no insurance. The state steps in. We have something called the Special Compensation Fund that substitutes as if they were the insurance company. But then they come after you, the business owner, and say, well, we had to pay, $20,000, $30,000, $40,000, $50,000 in benefits. We want that back, and we're going to charge you an enormous penalty. And I can't remember what the penalty is, but I believe it's something like 2/3 or double or something like that of whatever they paid. It's an enormous penalty. It's not worth the risk. If you have employees, buy work comp insurance. Frankly, work comp insurance is not that expensive.
We're getting a little short on time, so a quick answer to this one maybe for each of you. Can you give general advice to an injured worker, I'm presuming, to avoid losing the case?
You want to hear from the insurance company
Yes,
attorney?
sure.
Tell the truth. I think that's the biggest thing, because the inconsistencies will, I think, undermine credibility every time, and the truth sorts things out.
And try not to do something really, really dumb, okay?
It's good advice generally.
The employer offers you light duty, okay? So you say, oh, I don't want to do light duty. I'll just quit. Well, thank you. You just ruined your case. Or every doctor in northern Minnesota says, you ought to have this simple little surgery. It'll cure your problem. And you say, I don't want to do that. Well, those are the kind of things, even if the law says you don't have to have the surgery, the judge is looking at you and they're going, oh my God, that kind of thing. They usually do that once they leave the bench, though.
I don't know if I can add anything. Tell the truth and don't be stupid. Those are 2 very good pieces of advice.
I think we have about 1 minute left. Sean, you can get this one. I got hurt. I'm on workers' comp. Everything seems fine. Just got a call from a QRC. What's that all about?
Oh, a QRC, it's Qualified Rehabilitation Consultant. That's somebody who's going to try to help you get back to work. They're going to work with your employer to try to get you a job within your restrictions, things like that, and maybe look for other work if you can't return to work.
Kathy, we've got about 30 seconds. Tell us about retraining.
If you are unable to return to your regular employment without further skills enhancement or re-education, retraining may pay your way to do that through the work comp system.
What are the odds of that happening?
It's rare for a college degree, for example, but maybe some computer skills enhancement or some minor skills enhancement will happen.
Once in the blue moon.
Yeah, I mean, we see statistics. It's very rare. I mean,
It is.
the
And that's a
people who
whole
get
other topic of
retrained
discussion. So
are
It's a failed system in terms of what they have for retraining because it just almost never happens. You have to see the pigs flying usually.
okay. Well, that's all the time we have. I want to thank the panelists for sharing their knowledge with us tonight. Remember, you can watch this show again online at www.wdse.org or on the Falsani Balmer, Peterson, Quinn, and Beyer website, falsanibalmer.com. Please join us again next week when we answer your questions about criminal law. I'm Jim Peterson. Good night.